Well, good morning or good afternoon, depending on where you are and what's appropriate. My name is Barry Penner. I'm the Managing Director of the Canadian International Internet Dispute Resolution Centre, located in Vancouver, British Columbia, Canada. We are today hosting a webinar. We're glad that you were able to join us, pulling back the curtain, looking into the whole issue of internet domain name dispute resolution. And what is it exactly that decision makers want to hear? And what must be established in order for complainants to prove their case? This is an interesting and emerging area of the law in multiple jurisdictions. And I'm so pleased that you're able to join us today. And I'm equally pleased to be joined by two very prominent counsel that practice in this area. First of all, I'd like to introduce Georgina Danzig, who's a partner with the Toronto-based law firm of Kestenberg Siegel Lipkus LLP. Georgina practices in intellectual property and looks after protecting those intellectual property rights and the capital of those rights for her clients. She works to design proactive and defensive solutions to combat counterfeiting, privacy infringement, fraud, and theft of intellectual property and confidential information, and is a preeminent authority on counterfeiting law in Canada. The World Trademark Review gave her the highest ranking, gold, for anti-counterfeiting lawyers in Canada, and she's one of only 3 lawyers in our country in Canada to achieve that ranking. She actively litigates before the Federal Court of Canada and Ontario's Superior Court. She has extensive experience dealing with extraordinary remedies such as anti-pillar orders, preservation orders, and other forms of declaratory and injunctive relief, and has expertise in all aspects of Canada's border enforcement regime in relation to counterfeit goods and pirated works. Georgina is a frequent lecturer, published author, and media commentator on counterfeiting and related border enforcement. She is the past chair of the Canadian Bar Association's Counterfeiting and Trade Offences Committee, and Georgina is the current chair of the Canadian Bar Association's National Intellectual Property Section. Our other key host here today, participant in this webinar, is John Rogers. He's a senior administrative law and business professional with extensive experience as an arbitrator, administrative law adjudicator, and chair of professional disciplinary panels. In addition, John has experience gained from owning and operating an advanced technology business. Currently, John has restricted his legal practice to third-party administrative law review matters, and his business involvement is limited to that of being an angel investor, actively involved in more than a dozen tech startups. We'll move to the next slide. And I'll start by giving a bit of an overview of what we're going to be doing today and a little bit about the Canadian International Internet Dispute Resolution Centre and what we do. So to begin with, we'll go through the matters that you see on the screen, including a comparison of the key differences and similarities of policies between what's known as the Uniform Dispute Resolution Policies and the Canadian Dispute Resolution Policies applicable to different domain name addresses. Legal tests, the remedies that are available depending on the policies that you're pursuing your claim under. And interestingly, we'll be delving into a case study to try and apply some of these principles and the legal tests that are at hand. And then get into the perspective of a panelist such as John Rogers, what it is exactly that he's looking for when cases come before him. Next slide, please. So, as mentioned, there are similarities and differences. Let's just start, though, by defining what is UDRP. I mentioned that's the Uniform Dispute Resolution Policy, and that is applicable, and it's been developed by something called ICANN, another acronym, ICANN, which stands for the Internet Corporation for Assignment of Names and Numbers. And while it's headquartered in Los Angeles, California, it's global, and they set the parameters for many of the things that take place behind the scenes on the internet, including the development of this domain name dispute policy. It's intended to provide quick, inexpensive, and fair resolution for disputes with domain names that end with the suffix that you'd be familiar with, .com, .net, .org, and many others. In comparison, the Cdrp, Canadian Dispute Resolution Policy, applies to domain names that end with .ca, so the Canadian variant. In all cases, for UDRP, or from Cdrp, we're looking at issues that deal with bad faith allegations or abusive in the case of UDRP registrations, these generic top-level domain names and the country code domain names. Next screen. So as mentioned, the UDRP cases, which again, the UDRP is developed by ICANN, applies to more than 1,200, I think the last count, 1,236 generic top-level domain names, as well as some countries code-specific top-level domain names. Next slide. Whereas in contrast, the Cdrp applies only to .ca website names. And there have been more than 450 disputes brought forward since the Canadian Internet Registration Authority, which established the Canadian Dispute Resolution Policy, was established way back in 2002. And you can see some of the names below there that were the subject matter of various disputes. The Canadian International Dispute Resolution Center, of which I'm managing chair, and our parent organization, the Vancouver International Arbitration Center, has been a provider of services to resolve these disputes for .ca for about 18 years now. But we formerly conducted business as known as the BC International Commercial Arbitration Center, but have since developed a subsidiary, CII-DRC. Next slide. So here's a look, in case you haven't already gone to it, here's a look at the main page of our website. We developed last year an online platform to resolve these disputes. We are one of 6 service providers in the world authorized by ICANN to handle the UDRP cases. And we're one of 2 dispute resolution centers in Canada authorized to deal with .ca disputes. But in all cases, those matters, you would go through this portal, this opening page of our website. You can see the web address there at the bottom of the slide, CIIDRC.org. And this is what you'll find when you get to the opening page. Next screen. And thereafter, you're confronted with a choice. Do you want to proceed to the left for the Cdrp? Are you dealing with the .ca case? Or are you dealing with something else like .com or .net or .org? In which case you choose the blue banner on the right-hand side for the UDRP. And then from there, the website takes you in and gives you an opportunity to file a complaint, as you see there in the top left, uploading the documents and putting forward the evidence that you can marshal to establish your case. And we'll talk about what those tests are, those requirements. And at the bottom right, you see that if you're on the receiving end of a notice, you can respond to a complaint in a similar fashion through the website. Next slide. So what's the underpinning for all of this? Well, when you register a domain name with the registration authority, when you're doing that, you're entering into a legal agreement. And those agreements contain a requirement of an administrative proceeding in the event that there is a dispute. So if you're the registrant, in order to get your name secured, the domain name that you want, you're signing an agreement. And in that agreement, you're agreeing to participate in this process and to be bound by it. Doesn't mean you can't later go to court to appeal the outcome, but it does mean that you will be subject to these the administrative proceedings under either UDRP rules or the Cdrp rules of procedure. Next screen. So I mentioned again that there's similarities and differences. Here are some similarities. In all cases, the policies describe what is the purpose, who's eligible, what is the basis or the legal test that's required to be met in order to challenge someone's right to use a certain domain name, and then what are the remedies available if you're able to establish that someone is making an improper use of a domain name. Next screen. So again, keeping up with the similarities, these rules are intended to ensure procedural fairness, give you information about the form of how to make out your complaint and how to provide a response, what the response has to contain. It sets applicable time limits tells you what language is available to make your complaint, whether it's English or French or other languages of choice. Define panel selection and panel powers. So the process of how do you choose who will be your decision maker. Next slide. So, of course, in order to initiate a complaint, there comes the necessity of paying a fee to initiate the process. Our fees, I think, are quite competitive with the other providers around the world. And you can see provided a link there for what our fees are, whether it's a UDRP dispute or a Cdrp dispute. But that's the first thing to initiate your complaint. So you submit the details as required and pay the fee. And then we kick into gear and provide a verification. We check on the identity of the person that's registered the domain name in the first instance. And then if those tests are met, we request that a lock be placed on the domain name. And we'll be coming back to that lock process, which is fairly unique and very important in this whole process. Next, our staff at CII-JRC will do an administrative compliance check, again, to make sure that the necessary steps have been taken. The registrant then, that is the person that's on the receiving end, the respondent, has 20 days to file a response. And that's whether it's a UDRP complaint or Cdrp. The panel decision must be rendered within 14 days if it's a UDRP dispute, or 21 days if it's Cdrp. And if you're wondering why the difference, perhaps we can put it down to we have the metric system in Canada. Number 6, if a complainant is successful, the domain name is ordered to be transferred and must be done within 10 days if it's a UDRP case, or 30 days if it's a Cdrp decision. Next slide. Now onto this business of the lock. This prevents the holder of the domain name from selling or otherwise transferring that name. So it freezes it until the matter is resolved one way or the other. What will happen then is the provider will contact the concerned registrar, or that would be UDRP provider, or if it's a .ca case, then it goes straight to the Canadian Internet Registration Authority. And then the domain name is locked, again, if the prerequisites are met, and that name cannot be sold or transferred until the matter is heard or otherwise disposed of. Next. So there are 3 possible outcomes. You can result in a decision that the name must be transferred, the rights of that name are transferred to the person making the complaint, or that the domain name be canceled and not used, in other words, deactivated, and or dismissed if the tests are not met. Next slide. And then once the decision is rendered within those time periods as we discussed, then in the case of a Cdrp dispute, the decision is implemented after 30 days, and if it's a UDRP, after 10 days. Next slide. So again, a successful complainant, once that process has taken place, and if the decision's been made to transfer the name and that the complainant's been successful, then that complainant needs to enter into a registration agreement with whoever the provider is, whether it's Cdrp or .ca, or in the case of a UDRP case, with ICANN's certified registrar, a name that is familiar and popular out there, is, for example, is GoDaddy. And then you provide contact identification to the respondent's registrar, that is the person on the receiving end and the losing party. You provide that information to their registrar in order to effect the transfer. Next slide. I think we just skipped over number 18. So at this point, to get into some more of the details of the differences as well as the similarities between UDRP and Cdrp cases, now I'll turn to Georgina Danzig to take it over from here. Georgina?
Thanks, Barry. As we've just heard, both the Cdrp and the UDRP are administrative proceedings defined by their respective policies and resolution rules. The CIRA domain name dispute resolution policy was modeled after the Uniform Dispute Resolution Policy, resulting in many similarities, but there are some significant differences. And right now we're going to take a look at what some of those are. Next slide. We are firstly going to look at the issue of jurisdiction, specifically, what types of disputes are dealt with under the rules. Second, we are going to look at who can file a complaint. Third, we're going to examine the three-part test and how it applies under both sets of rules. And finally, we're going to consider the remedies. What do you actually get if you win? But for that matter, is there a risk to you if you lose? And we are going to compare these elements within the two systems. Next slide. Jurisdiction. So in terms of the subject matter jurisdiction covered by the two policies, I venture to say they're essentially the same. And that is, they are designed to resolve disputes concerning alleged abusive or bad faith registrations of domain names. And an example of a dispute that would squarely fall within the jurisdiction of both policies would include domain names that infringe trademarks or domain names that attempt to confuse the public as to who the true owner or operator of the domain name really is. Next slide. Standing. So standing basically means who has the right to file a complaint. And this is one area where the differences between the UDRP policy and the Cdrp policy vary greatly. To have standing to advance a UDRP complaint, the only criteria is that an individual or company has a dispute, and then subject matter jurisdiction concerning an alleged abusive registration of a domain name that relates to a top-level domain. That's it. That's all you need. Pretty straightforward. In sharp contrast, to have standing to bring a Cdrp complaint, the complainant must be eligible. And to be, quote, eligible, the complainant must satisfy one of the Canadian presence requirements for registrants, which are contained in the CIRA policies, rules, and procedures. So let's take a look at what some of those are. Next slide. Essentially, to be eligible to advance a complaint respecting a .ca domain name, the complainant must satisfy one of many enumerated Canadian presence requirements. That is, the complainant must meet the criteria identified on the slide. For example, is the complainant a Canadian citizen? Or is the complainant incorporated in Canada? If the answer is yes to those questions, and there are many others, then the complainant is, quote, eligible to proceed. But if the complainant does not meet one of the Canadian presence requirements, essentially a residency requirement, it can still be an eligible complainant if, and I direct you to the bottom bullet on the slide, if it is the owner of a corresponding Canadian trademark registration, not an application or a common law trademark, but an actual registration. Owning a trademark at common law or having filed a trademark application but not secured a registration is not sufficient to meet the eligibility test. Accordingly, in the Cdrp, it very much matters where the complainant resides or what the connections are that the complainant has to Canada. And as a last but critically important resort or fact, if it owns a registered Canadian trademark. This concept will be something we will look at further when we get to part 3 of the presentation, which is the case study. Next slide. Oh, but there is one more thing. An interesting anomaly that can arise in dealing with a domain name dispute. Just because you qualify as an eligible complainant does not necessarily mean you are eligible to register a .ca domain name. To qualify to register a .ca domain name, the trademark that the complainant is relying on to meet the Canadian presence requirement must appear in its exact form within the disputed domain name. Close just doesn't cut it. So if, for example, the complainant is not Canadian, but has a registered Canadian trademark, and the disputed domain name is very close to that trademark, but not exact, for example, a typo squatting scenario, the complainant may be precluded from actually transferring and registering the disputed domain name. And I believe this key difference in the two regimes, the UDRP and the Cdrp, stems from the stated policy objective of CIRA, that the .domain space, and I quote, should be developed as a key public resource for the social and economic development of all Canadians, end of quote. The imposition of the CPR rules, the Canadian presence rules, is consistent in every way with that policy objective. But the expression of that policy differs markedly from the policy objectives of WIPO and the UDRP regime, which is by express policy and design international and requires no consideration to the jurisdiction of the complainant. Next slide. The next element we want to consider in the two different regimes is the three-part test. The test to establish whether a bad faith or abusive registration of a disputed domain name exists. And the test is similar in both regimes. Both use a three-part test. Both require that the complainant prove all three parts of the test to be successful. And both set the burden of proof on a civil standard, which we call a balance of probabilities. Notwithstanding these obvious similarities, there are some important differences that we're going to highlight for you now. Next slide. The three-part test. Under the Cdrp, the complainant must prove these three things. The registrants.ca domain name is confusingly similar to a mark in which the complainant had rights prior to the date of registration of the domain name and continues to have rights. Second, the registrant has no legitimate interest in the domain name. And third, the registrant has registered the domain name in bad faith. Now let's look at the three-part test under the UDRP. Next slide. Thank you. The domain name, the complainant must prove that the domain name registered by the respondent is identical or confusingly similar to a trademark or service mark in which the complainant has rights. The respondent has no rights or legitimate interest in respect of the domain name, and the domain name was registered and is being used in bad faith. Next slide. So this slide sets out the two regimes side by side and provides a good visual for you to identify some of the similarities and some of the differences. For example, under the Cdrp, the complainant's trademark rights must predate the domain name registration, and the complainant must continue to have such rights. Under the UDRP, the date of registration of the trademark being relied upon is not relevant to the first element of the test. Under the Cdrp, the complainant needs to have rights in a mark, but under the UDRP, it needs to have rights in a trademark or service mark. Is there a difference? Under the under the Cdrp, the complainant only needs to show bad faith registration, while under the UDRP, bad faith registration and use must be established. Let's break this down even further. Next slide. So for the first element, the complainant must establish two things. that it has rights in the mark or rights in the trademark and service mark, and that the disputed domain name is identical to or confusingly similar to the mark, tweaking in the language depending on whether we're in the UDRP context or the Cdrp context. Next slide. Rights in the mark. Both the UDRP and the Cdrp protect trademarks registered and at common law. However, the Cdrp protects more than just trademarks. It protects what it calls marks, which are defined more broadly to include, for example, trade names used to distinguish the goods or services of the complainant from the goods or services of others. The Cdrp has a broader mandate about what is included within its realm of protection. If a complainant is relying on an unregistered trademark or trade name, it will be required to proffer evidence to establish that the unregistered mark or trade name has acquired what's called a secondary meaning, essentially that the mark or trade name is a distinctive identifier for consumers to associate with the complainant's goods or services. Next slide. So once the complainant establishes rights in the mark or the trademark or service mark, as the case may be, it must then establish that the disputed domain name is identical to, if we're in the world of UDRP, or confusingly similar to the mark. The test for what is confusingly similar is rather narrow. Under the Cdrp, it's what's called a resemblance test. The panel shall only consider whether the disputed domain name so nearly resembles the mark in appearance, sound, or idea suggested by the mark as to likely be mistaken for the mark. And this test is judged by the standard of first impression and imperfect recollection. Under the UDRP, the test for confusingly similar is framed as a recognizable test. This test involves a reasoned but relatively straightforward comparison between the complainant's trademark and the disputed domain name, which typically involves a side-by-side comparison of the disputed domain name and the textual components of the relevant trademark to assess whether the mark is recognizable within the disputed domain name. When using both tests, the top-level domain is not considered. That is, the panel is required to ignore anything to the right of the dot and only consider what is there to the left of the dot. Next slide. Now we're on to the second element of the test, no legitimate interest. To meet the second element of the three-part test, the complainant must establish that the registrant has no legitimate interest in the domain name under both regimes, or no right in the domain name under the UDRP. The Cdrp and the UDRP both provide a non-exhaustive list of what constitutes a legitimate interest in the disputed domain name. The UDRP provides three circumstances in which a registrant can demonstrate a legitimate interest, and they include the ones that I've listed on the screen. For example, that it engaged in the bona fide offering of goods or services before it had notice of the dispute, or that the registrant of the domain name was commonly known by the domain name. Perhaps it includes a family name or an unregistered trademark, or that the registrant is using the domain name that it incorporates the complainant's trademark for an acceptable non-commercial purpose, which is called fair use. For example, if it's providing a criticism. By contrast, the Cdrp lists 6 circumstances in which the registrant can demonstrate it has a legitimate interest in the domain name. And each of these lists are available to you by visiting the CII-DRC website, and they're a good opportunity for you to review and compare the differences and similarities between the two lists. They are essentially the same, but but the Cdrp list is slightly broader and longer. Next slide. So the challenge with the second element is that it requires the complainant to prove a negative, that the registrant has no right. And as we know, proving a negative can be difficult, particularly in circumstances where a complainant may have very little information about the identity of the registrant. And that's why what's built into both regimes is a shift in the burden. Essentially, the complainant is not required to prove on a balance of probabilities that the registrant has no legitimate interest. It simply has to put forward some evidence of no legitimate interest. Once it does that, then the onus shifts to the registrant, and at that point, it's the registrant's obligation to establish that it has a legitimate interest in the domain name. And I would like to point out that the registrant needs only establish one circumstance of legitimate interest in order to succeed. Next slide. Lastly, the third element of the test is bad faith. It's what we all talk about when we're talking generally about domain name disputes. Under the UDRP, a complainant must establish both that the registration and use of the domain name were done in bad faith. And under the CDRP, the bad faith test applies only to registration. This means that compared to the UDRP, the CDRP relieves the complainant of the burden of demonstrating bad faith use of the domain name. Compared with the UDRP regime, however, the CDRP denies the complainant the opportunity to rely on bad faith use where evidence of bad faith registration may not be present. So this is another element, just like the element where we were dealing with Canadian presence requirements. This bad faith element is an area where the two regimes are not fully aligned. Next slide. So these are examples of bad faith circumstances. And the non-exhaustive list of bad faith circumstances is summarized on your screen and paraphrased to broadly include both the CDRP and the UDRP. I'm going to quickly summarize these factors. The first factor covers prototypical cyber piracy, and it applies in both regimes. The second factor covers blocking activity, and that's when the domain name is registered to prevent or block the complainant from registering its mark as a domain name. But it should be noted that it only rises to the level of bad faith when that conduct represents a pattern of conduct. The third factor covers activity that is disruptive to the complainant. For example, when the domain name is registered to disrupt the complainant's business in a situation where the registrant and the complainant are competitors. And the last element of bad faith can be evidenced by the intentional attempt to attract for commercial gain internet users to a website by creating confusion with the complainant's mark as to the source, sponsorship, affiliation, or endorsement of the registrant's website, location, product, or services. And when we get to the case study, we're going to go through some of these elements and see how they apply in a practical sense. And then next slide, in terms of the remedies, they're the same in both regimes, but a little bit different. So if a complainant is successful in either regime, it can request that the domain name be transferred to it or canceled. But irrespective of its success, it's not entitled to a cost award. The other two remedies on the slide are regime specific. For example, in a UDRP proceeding, the registrant can ask that the panel determine whether the complainant engaged in reverse domain name hijacking. but that determination is beyond the jurisdiction of the Cdrp. Also, if the registrant in a Cdrp proceeding is successful and establishes on a balance of probabilities that the complaint was commenced unfairly or without color of right, designed to cancel or obtain a transfer of the registration, the panel in the Cdrp may actually order the complainant to pay to the registrant an amount of up to $5,000 Canadian to defray the registrant's costs. And that type of award is not permitted in a UDRP proceeding. Next slide. So the bottom line is there are a lot of similarities between the two regimes, though there are also some very important differences. But in both regimes, I have to say, as a litigator, the advantages outweigh litigation. They both use a three-part test. There is no live testimony, no motions, no personal service required. There's no need to prove damages. Your submissions are limited to a fixed number of words. It's less costly. There's a filing fee plus the cost of your legal counsel. The fee schedule, as we've already indicated, is available to you on the Cdrp website. And the domain name is locked during the dispute. No need to bring an interim or interlocutory motion seeking to preserve the right pending the outcome of the action or the arbitration. It's done for you through an administrative process. Next slide. I would now like to introduce my co-presenter, John Rogers, to provide us with the perspective of an active panelist. He's going to take us through the fact pattern that has already been circulated, and he and I will then discuss that fact pattern with you. John, over to you. You're muted, John. There.
Thank you. So I was going to say it helps if I unmute. Thank you, Georgina, for that. What Georgina and I have tried to do, because there's a lot of technical points going through the differences between them, we tried to come up with a case study whereby we could apply some of the points that Georgina spoke about in actual real time. And I'm going to touch base with that. And oh, by the way, as we come through, there's a chat function. So if you have questions of any of the previous presentation, or even of the questions that we may come up with, or you may come up with during our fact situation, or the facts discussion of the facts situation, don't hesitate to use the chat function. And then what we'll do is at the end of it, try and address it. Before I get to the fact situation, let me, if I may, give you a little bit about the panel approach. The panel is appointed by, I call it Cdrp for short, CIIDRC, from the roster of panelists. Usually, or the default is a 3-member panel. However, where a response is not filed by a registrant, then the complainant can ask for a single-member panel. Quite often, where there is no response filed, the complainant asks for that because it is a cheaper process. If a panel member is appointed, that member of the panel is required to sign a rather long named document, the acceptance of appointment as a panel and statement of independence and partiality, which basically says you are independent and you are impartial. In the case of a 3-member panel, there is usually a consult once a complaint and the response are circulated among the panel members. There is a discussion among the panel members. Usually the appointed chair is the person who writes the decision, and then circulates to the other members of the panel who have an opportunity to comment. And by the way, the rules contemplate the possibility of a dissent. So it would, in the case of a three-member panel, there would be the question or the situation where you could have a dissent that is filed. Moving on to the fact situation, could we do the next slide? Thank you. Some of the, you have, as Georgina suggested, the fact situation in front of you, hopefully, including the exhibits. If I can, just to highlight some of the facts that certainly stand out for me as a panelist. Firstly, the fact that MFW has been around since 1976. It's not a new boy on the block. It registered its trademarks in 2015. It registered its domain names in the US and Canada in 2017. In the year that the 4 disputed domain names were registered, which was 2019, it did $6.5 million in sales in North America. The fact it is a US company carrying on business in the US and Canada, and I make no qualms about the fact that Georgina and I have buried into some of the fact situation some points, just like a good law exam, that are a little hidden, that we can come forward and express our brilliance by finding it. The other thing is the similarities among the exhibits, the websites, in exhibits A to D. And so what these facts, prima facie, and the exhibits suggest is that there appears to be a clear case of knocking off of MFW's goodwill. So if this were presented to me, say, as a single panelist, I would read through it to try and get an overall first impression. And what I'm looking for, whether it be under a UDRP or a Cdrp situation, is the general intent of each of the policy regimens. UDRP is to address cross-border trademark abusive domain name registration, or what is called cyber squatting. Cdrp, it's bad faith registration in the Canadian form in a manner that can be dealt with relatively inexpensively, but it's bad faith that is the focus is. And I do that to compare it against one of my favorite cases, which happened a number of years ago in the UDRP environment, and it actually came out of Vancouver. There was a chap by the name of Mr. Manning. I gather his first name was Albert and his second name was Robert or something. And he registered a domain name for his own use and used it personally rather extensively. And then there was this large international, I think it's a clothing company, Georgina knows better than I, by the name of Armani, who objected to the use by Mr. Armani of www.armani.com. And commenced a complaint against Mr. Armani for cyber squatting. Mr. Armani was easily able to demonstrate that this was not the case, that he in good faith had registered it and used it in good faith. I mention that because to me, as I read through a complaint and the response, I sort of look for those 2 points before I delve into the detail too much. So if you are preparing documentation, you may want to emphasize those 2 just general approach or context. Can we do the next slide, please? The case study points out the 4 domain names. Note that initially the WHOIS does not disclose the identity of the registrants. The 4 domain names resolve to different websites. And as I said, we'll get to the slides and to the exhibits in a minute, but they're all the domain names resolved to websites are very similar. One of the things that I want to point out on this slide is the director of e-commerce for MFW received a letter from a lawyer offering to sell the disputed domain names for $500,000. And needless to say, I think Georgina and I'll come back to that when we sort of go through the process. Next slide, please. And if we go through the B, C, and D, you'll note, and you have them in front of you, you'll note the similarities between the various exhibits and the slides to which the disputed domain name resolved. The issues, and I'm going to now turn this over to Georgina, back to her as the, shall we say, MFW has been very wise and has hired a very experienced and learned counsel to assist in this manner and make the presentation. Over to you, Georgina.
Thanks, John. Right. So to succeed under the Cdrp, my client must show that the domain names madeforwalkingcanada.ca and makeforwalking.ca are confusingly similar to a mark in which my client has rights, and that these two domain names were registered in bad faith. In addition, my client has to provide some evidence that the registrant has no legitimate interest in these two domains. But if the registrant can show a legitimate interest in the domain, my client's complaint will fail. On the UDRP side, to succeed, my client must show much the same things, that the domain names madeforwalkingus.com and makeforwalking.com are identical to or confusingly similar to a trademark or service mark in which my client has rights, and that these two domain names were registered and used in bad faith. In addition, my client has to prove some evidence that the registrant has no rights or legitimate interest in these two domains. But if the registrant can show it has rights or a legitimate interest in the domain, my client's complaint will fail. So what do we need to do? Next slide. First, we're going to talk about, with my client, I'm going to discuss eligibility. I'm going to discuss whether consolidation is appropriate. We're going to consider how best to meet the three-part test and what remedies are available to us. And I can tell you, in my meeting with my client, MFW, they communicated two primary objectives. First, to try to keep their costs to a minimum, surprise, surprise. And second, to ensure that all four domain names are transferred to them. That's what they want. Let's go for the brass ring. That's what they want. And so it's in the context of those objectives that I'm going to make the following submission. Next slide. First, eligibility. I'm aware that my client's dispute involves 4 disputed domain names, 2 that concern a .com and 2 that concern a .ca. With that in mind, I want to qualify my client as a complainant in both the UDRP and the Cdrp proceeding. So in order to frame my submission, I've considered the following. I've asked for and obtained a corporate profile report evidencing the incorporation of Made for Walking in the US. And as we know from the fact, that was from 1976, and it's still a valid incorporation. But this immediately raised some concerns with me about whether my client, the US company, can meet the Canadian presence requirements under the Cdrp and qualify as an eligible complainant. But I then remembered that the trademark exception to the traditional made in Canada requirement may be helpful. So I then asked for and obtained a printout from the CIPO, the Canadian Intellectual Property Office, and the US Patent and Trademark Office for the 2 registered trademarks Made for Walking for a number of reasons. First, it validates the date of registration of the trademark. It confirms that Made for Walking is the registered owner of both trademarks, and it identifies the exact reference to the trademark that I need to rely upon to meet the Canadian presence requirement. I'm also aware that my client's Canadian trademark, registered in 2015, is still current, and I'm satisfied that the trademark is valid and that the rights being relied upon by my client predate the disputed domain name registration, which took place in 2019, and that my client continues to have those trademark rights. So based on my understanding of the policies and in reliance on the documents referred to above, which I'm going to attach to my complaint, I make the following submission. Regarding the UDRP complaint, I submit that Made for Walking is an appropriate complainant because the complainant can be any individual or company with a dispute concerning the top-level domain, which in our case is madeforwalkingus.com and makeforwalking.com. So I submit with respect to that proceeding, our client meets the threshold. Regarding the Cdrp complaint, I submit that the complainant satisfies one of the CPR requirements by being the owner of a trademark, which is the subject of a registration under the Trademarks Act. But I am aware that satisfaction of this requirement limits permission to register a .ca domain name to one that consists of or includes the exact word component of that registered trademark. So accordingly, I submit to the panel that Made for Walking is an eligible complainant to advance the complaint against both .ca domain names, Made for Walking Canada.ca and makeforwalking.ca. The tricky part is what impact this may have when we need to address the remedy. John, where am I on this?
Thanks, Georgina. Yes. Firstly, I should, in fairness, Georgina, the choice of musical selection was not hers, it was mine. So please don't hold that against her. Yes, definitely, I think you have satisfied the complainant requirements. You've demonstrated the registered trademark in Canada, and you've demonstrated that it is a domain name that is eligible under the UDRP. What we have not included, because of the amount of paperwork that would be required or documentation, usually what Georgina would be filing with her complaint would be examples of both the trademark and of the utilization of the website to which the domain names resolve, so that would be before the panel as part of the filing of the complaint. And again, we'll touch base on the remedies when we get to to deal with that a little later. We do the next slide, and back to you, Georgina.
Sure. Thanks, John. Okay, feeling emboldened because I'm on a roll here. We're going to talk about next consolidation. And you may recall that one of my client's primary objectives was to keep the cost down. So consolidation, I thought, might be a good avenue to explore with my client. Both the Cdrp and the UDRP provide for consolidation, and that is the ability to file one complaint to cover more than one domain name. And this would align with my client's instructions to save costs. And as you can see from the screen, however, the tests are different. So under the Cdrp, the test is narrow. It is simply and simple. Is the registrant information the same for all registrants? Okay, easy enough, or maybe not. Under the test for the UDRP, it's a broader test. Are the domain names or corresponding websites subject to common control, and is consolidation fair and equitable to all parties? So in order to frame my submissions on consolidation, I've considered the following facts. First off, as you may recall, the Who Is report does not disclose the identity of the registrant. The Who Is report simply tells me that the registrant's identification is protected by a privacy service. That's a little disconcerting if I'm trying to establish under the Cdrp that the registering information is the same for the registrant. But let's look at what other facts I have. You may recall that there was a letter that was delivered to my client, which was authored by one lawyer and offered to sell the 4 disputed domain names to my client for a lump sum payment of $500,000. Well, I would suggest that there very well may be a connection between the registrants if they've all engaged the same counsel and have all decided to move forward in unison to ask for one collective price in order to sell the 4 domain names. To me, that could be an indicia that the domain names are subject to common control, which is a relevant consideration in the UDRP context. Also, the screenshots of the 4 websites that correspond to the 4 disputed domain names, which John showed us earlier in the presentation, show that each registrant is selling what appears to be the same line of booth, using a very similar style, font, and layout for their website, and using a similar naming convention for the products being offered for sale, sort of a 3-letter acronym for each product being offered for sale. So to me, that's also an indicia of that perhaps they're all owned by the same party or subject to some kind of common control. And then finally, the dates of registration for the 4 domain names. They're all very close together. They're all in 2019. 2 of them are in May and 2 of them are in June. And I would suggest also that that's coincidence, perhaps not, perhaps, but again, possibly an indicator that the domain names are subject to common control. So notwithstanding that the tests for consolidation are different, I would advance 2 consolidated complaints, one in the UDRP regime and one in the Cdrp regime. I'd like to hear from John as to what he thinks my chances are for consolidation, and also whether I have an opportunity to revisit my position based on certain disclosure that I may receive once the complaint is filed.
Thanks, Georgina. Yes, I think your approach is correct. Although you suspect very strongly that the 4 domain name owners are, if they're not the same party, are certainly controlled by the same entity, it makes sense to file, if you will, 2 complaints. The moment you do so, Cdrp will examine them, will go through to the respective registrars, and will find out who the actual owner, the registrant of the domain names are, and then we'll come back to you. So at that point, you will then be advised that, for instance, for the .ca registrations, they are different registrants, and the registration information is not the same. And similarly with the UDRP. However, you've already submitted with respect to the UDRP that the consolidation should be considered. With respect from the panelist perspective, what I would be looking for is to see before, firstly, grant you the right to come back. Certainly, if if you wish, under the Cdrp, because as we're going to show, you're only entitled to against one registrant. But before doing that, I would look to see whether or not the registrants had filed responses. Now, on our fact situation, they've not done so, so obviously that makes it a lot easier. But before, sort of getting into the consolidation, I would certainly want to await the response from the respondents / registrants. So my response to you would be definitely consolidation under the UDRP and the right or granting you the opportunity, if you so desire, to file two separate, but if you will, the same complaints, but aimed at different domain names under the Cdrp. Back to you.
Thanks, John. So that's the next slide then, which is suggested that we may have some difficulty under the Cdrp and have a better shot under the UDRP. So, okay, thanks for that. Let's move on to the three-part test. Next slide. First, rights in the mark. So I don't think we need to spend much time on this. Based on the trademark registrations that we've already looked at and spoken about, I submit that it's uncontroverted that the complainant has rights in and to the trademark made for walking, and that it is registered in the United States and in Canada in association with footwear. And for the purposes of my Cdrp submission, I also submit that the rights being relied upon by my client predate the two disputed domain name registrations, and that my client continues to have those rights at this time. So I don't think that's very contentious. I'm going to move on to the second part of this first part of the test, which is confusingly similar to a trademark. So in this section, I submit to you, John, that all four domain names are confusingly similar to the registered trademark made for walking, using both the recognizable test under the UDRP and the resemblance test under the Cdrp. Using either test, the relevant comparison is to be made is between only the second level portion of the disputed domain name and the complainant's trademark. So with respect to the two domain names, made for walking Canada.ca and made for walking US.com, I submit the following. First, the two disputed domain names incorporate the complainant's made for walking trademark exactly. And merely adding the geographic terms Canada and US to the end of the trademark isn't going to do it. The additional words of Canada and US, I would submit, do not differentiate the domain name from my client's trademark. And the insertion of those words, I submit, are not sufficient to overcome a finding of confusingly similar. The addition of these two geographic references are not distinctive in this context, and it is well established that the addition of generic or descriptive or geographic terms will not overcome a finding of confusing similarity under both regimes. And in fact, I submit that the use of the geographical words actually add to the potential for internet customers to confuse the respondent's website with the complainant's website. Because my client has been selling shoes internationally, including in the United States and Canada, for over 50 years. It's got $100 million in revenue in the last 10 years. And it's also selling these goods using its domain name. Additionally, I would contend that the use of the disputed domain name, even with the geographic extensions, contributes to the confusion. They're making an unauthorized use of my client's trademark, and it is an exact duplication of that trademark. So as a result, I submit that the respondent's use of the disputed domain name is confusingly similar to my client's trademark. With respect to the two domains, makeforwalking.ca and makeforwalking.com, I also submit that it is confusingly similar to my client's trademark because changing one letter, the D to the K, K to the D, made instead of make, is not sufficient to avoid a finding of confusion under both regimes and both texts. Specifically, I submit that make for walking so nearly resembles the trademark in appearance, sound, or the idea suggested by the mark, this is the Canadian test, that it is likely to be mistaken for the mark. Those are my submissions on that point. John, do you agree?
Thank you, George. Well, how could I not? It's such a learned presentation. Again, from a panelist perspective, before I got into the details, what I would look for, again, back to my general purpose test, is to make sure this was not an Armani situation. And given the facts, obviously it is not. The two situations we have here are using geographic description or geographic inclusions to try and distinguish, and there is a lot of number of decisions to the effect that that does not work. Similarly, with the K versus the D in the make for walking versus the made for walking, we call that typo squatting, and there's a lot of precedent, if you will, to the effect that just because you decide to register amazzzzon.com, that is not that is permissible. So I agree with your presentation. I believe that you've satisfied the first element, Georgina. Back to you.
Thank you. So in respect of the next element, can we switch the thank you, no legitimate interest? There is a requirement that the registrant has, this is the shifting of the burden element of the case. So my job is to put before the panel that the registrant, that the complainant has some evidence that the registrant had, if we're in the broadest context, no rights and no legitimate interest in the mark. Depending if we're UDRP or Cdrp, it might just be no legitimate interest or no rights and no legitimate interest in the mark. So my client is the sole owner of both made for walking trademarks, which are identical and registered in 2 different countries. My client, as a result of that ownership, has the exclusive right to use its trademark in association with the goods or services for which it is registered, which in this case is footwear. My client has not granted a license nor given any authority to the registrant to use its trademark. So I would put that evidence forward, and that's to use its trademark in any way on the registrant for domain name or on the registrant's website. And I would submit that the evidence before the panel is that the registrant registered these four domain names well after the complainant had registered its trademark, and at a time when the revenue associated with my client's mark was significant. And I would put that fact in. I would also point out that the registrant, John mentioned the case of Armani, and I love that case. But in this case, the registrant's legal name has not been disclosed to me based on the facts that we have. But there is precedent that says that where there's no evidence of the name and the who is record for the disputed domain name is privacy protected, the registrant cannot be regarded as having acquired rights to or a legitimate interest in the disputed domain name within the meaning of that section of the policy. In other words, can't just say, oh, it's really my name if the who is report is privacy protected. They're precluded from advancing that ground for legitimate interest. Also, the domain names in dispute are not understood in Canada under the Cdrp provision to be a generic name of the goods in any language. And I also point out that the registrant is using the domain name for commercial activity, and that would eliminate any reliance on a fair use exemption. So this is the evidence that I'm going to put forward that I submit is sufficient to shift the burden. And short of adducing evidence on a balance of probabilities that the registrant does not have or does have a legitimate interest in the disputed domain name, I think that the complainant has met its burden. John, what do you think?
Thanks, Georgina. This is one of the more difficult situations for a panelist because you have no response. In other words, it's not as if you're hearing two sides of it. What you're doing is you're having to find, as Georgina points out, a negative, or at least an indication of the negative. What I would be doing is under the UDRP, trying to sort of, was the offering of the products, the boots on the website, a legitimate business offering, or was it more, did it more come across as an attempt at passing off on MFW's goodwill? Was there any evidence that I could see, and there's no obligation on me to go out looking for it because the respondent has chosen not to reply, but is there anything that the respondent, the registrant rather, was known by that name? And certainly there was no indication from the 4 websites that came forward that it was not a non-commercial or fair use of the domain name. So under the UDRP, I think that that Georgina has demonstrated that there's no legitimate interest. One of the interesting factors in the Cdrp is of the 6 components, 4 of them require a good faith component. In other words, the registrant would have to demonstrate that it was used in a good faith environment. And certainly on the facts before me, I'd have no trouble with that. The domain names were not the registrants' names, and there was no geographic identification under the Cdrp. So therefore, examining the element 2 of both the UDRP and the Cdrp, I agree with Georgina that the complainant has established element number 2. Back to you, Georgina.
Thanks, John. The last element, the one of, you can change the slide. We're going to talk about bad faith now. Great. So in the context of bad faith, under the Cdrp policy, the registrant will be considered to have registered the domain name in bad faith if the complainant can demonstrate that the registrant, in effecting the registration of the domain name, was motivated by any of the 4 general intentions set out in the policy, and we went over these earlier in the presentation. I would argue that the website to which the respondent's disputed domain name resolves seeks to take advantage of the fame of the complainant's trademark and the trust and the goodwill that the complainant has fostered amongst its consumers to, at a minimum, illegitimately increase traffic to the registrant's website for personal gain and commercial gain. There's also a possibility, although it's not in the fact, that once it secures the personal information of its customers, it may be engaged in phishing. We just don't know. But certainly, I think it is capitalizing on the goodwill and reputation and fame of the trademark in the design of its domain name and in choosing that domain name, in choosing to register those domain names, which I assert is a bad faith registration. Another fact that stands out for me is that the registrant registered the domain name primarily for the purpose of selling it to the complainant, or so I would assert, based on the letter we received, which purported to offer to sell these domain names for $500,000, which is an amount well in excess of the registrant's actual cost in registering the domain name. In addition, we've made out that there's no business relationship between the registrant and my client. And again, I would assert that they're attempting to divert unsuspecting customers looking for my client's legitimate product to their website. And once at their website, they're offering confusingly similar goods, perhaps counterfeit goods, but we'll say confusingly similar goods, thereby profiting at the expense of my client. So, John, what do you think?
Yes, I agree with you. The elements that I look at, and they're, if you will, roughly the same for both environments. The element of passing off, the similarity of look and feel of the websites, the similar look and feel, if you will, of the domain names, and as well the similarity of the products offered. Maybe we made our example websites too easy for that, but they certainly look that way. The second aspect is the almost concurrent registration of the domain names. Suggests very, very strongly an element of bad faith and an element of a common control. And then finally, although there have been, certainly under the UDRPs, some decisions that have held that just registering and selling domain names per se is not against the rules. I would suggest very strongly that an unsolicited offer from all four for $500,000 from one lawyer to the to MFW certainly smacks of bad faith. So yes, I would definitely agree with the finding that the third element has been established. Back to you, Georgina, on abusive process.
Next slide. So the abusive process. John, I more want to hear from you on this than speak to.
Sure, happy to do so. We raised the abusive process. It's not utilized that much, and especially not utilized, of course, where the respondent, the registrant rather, doesn't respond and obviously has no ability to be able to do that. But for instance, I mentioned the Armani case to start with, whereby the Armani folks came after Mr. Manny, claiming that they were entitled to have the name transferred. This could be argued, it wasn't at the time to my knowledge, but it could by Mr. Manny, but it could be argued that the complaint was brought by the complainant in bad faith to harass the respondent, or which was Mr. Manny, or to deny the legitimate use of the domain name. As it turned out, I understand Mr. Manny sold subsequently the domain name for a fair amount of money, so everybody was happy. But that could be an argument for a reverse hijacking. Similarly, under the Cdrp, if it could be established that the complainant brought the complaint for the purpose of attempting unfairly and without color of right to have the name either transferred or canceled, then there could be costs awarded to the registrant if that was the finding of the panel. There have not been a lot of those. Obviously, in this situation, I don't believe it's applicable, mainly because there's no response, but also it appeared to be a clear trading on the goodwill of MFW. So
what's the outcome?
Therefore, well, I was going to say, so we're ready for the decision?
Yeah.
Can we do the next slide, please?
Very.
So, the decision of the panelists is that, Council, you have made your case, and you are entitled to the remedy sought with respect to the .coms. I will order a transfer. With respect to the madeforwalking.ca, I will order a transfer because it fits within the requirements of the quote exact. However, the make for walking is not exact because it's typo squatting. But what I will order is that the domain name makeforwalking.ca be canceled. So to that extent, you are successful in that application.
Thank you. So let's go through the top 5 takeaways then that we want to leave with our audience, and then hopefully we have time for some questions. John, do you want to take us through this, or do you want me to do this?
You go ahead.
Okay. So in preparing the presentation today, we sort of put our heads together, the 3 of us, and came up with what we think are the 5 top takeaways for everybody. And we hope that you've learned these from the presentation today. Number 1, that the 2 regimes are procedurally and substantively similar. Second, that the 2 regimes use a similar but not identical 3-part test to determine if a domain name should be transferred or canceled. Thirdly, that the 2 regimes provide a fast, fair, and inexpensive dispute resolution process, providing limited but effective remedies. Next slide. The 4th takeaway is that the 2 regimes require evidence to meet the burden of proof. Can't just say it, you got to put in your evidence. And fifthly, that the 2 regimes differ primarily based on the underlying policy considerations, and that is most pronounced when you look at the eligibility and the standing sections and the rights to actually register in the Canadian context. John, do you have anything to add to that?
Yeah, especially on that last one, Georgina, and that is to emphasize that the major difference between the UDRP and the Cdrp is the Cdrp is based on a country code TLD. In other words, it is focused on Canadian aspects. So any submission based on a Canadian .ca under the Cdrp, keep that in mind, because that is something that the rules sort of contemplate, and certainly a panelist should be cognizant of. UDRP, it is much more on a globalized basis. I saw we've got some chats coming through. Shall we turn it, what do you think, Georgina? Turn it over to Barry and let him
Sure. Maybe he can
deal
guide us
with
with some of the questions.
questions?
Sure, and appreciate that our participants or the people viewing this presentation have submitted a number of questions. We have one from David Bowden, question to all of us. So let's assume you are successful, as we just saw here. How do you convince a recalcitrant registrar, to effect the transfer, whether they're inexperienced or just otherwise non-responsive? Any thoughts on that?
I think that is, if I can respond to that, as you in your presentation set out, Barry, the registrar's jurisdiction is a function of its contractual arrangements with ICANN. And if it's demonstrated that the registrar is not operating within the rules as prescribed by ICANN, and you pointed that out earlier, that not only the registrant, but the registrar is party to this contractual arrangement. I would suggest that that is something, firstly, I would, again, this is up to the provider, such as Cdrp, but I would suggest that that is something that first would be impressed upon the registrar, that they are not operating within the requirements of the contractual relationship. And if they still decided to operate on that basis, I think that's something that should be taken up with ICANN. Georgina?
Yeah, I agree.
Agree as well. We have a question from Bill Kaplan. Question about evidence. To prove confusingly similar, do you ever need to use or rely on a market survey expert, or do you just use go by a word analysis?
You know,
maybe John, in addressing that, and Georgina, you could talk about what is the burden of proof. What is the standard of proof?
sure.
Georgina, do you want to start?
Yeah, sure. So interestingly, the test is quite direct in the context of these types of proceedings. It's not. It's really very much about whether the element at issue, the trademark, is recognizable in the UDRP context within the domain name, or in the Cdrp context, so merely resembles it in appearance, sound, or idea suggested by the mark. I don't know. I mean, if you think that you need survey evidence to deal with this element of the test, then you're dealing in a very, you may not make the test even if you have survey evidence. In other words, they're really looking for a much simpler analysis than may be found sometimes in the context of infringement or passing off. They've defined the test to really be something that is almost obvious on its face. So I'm not saying that market survey or expert evidence is never necessary. It may be helpful, but the tests, I think, are trying to, I don't think the tests contemplate that level of challenge in terms of the analysis. In fact, under the UDRP, they sort of say it typically involves a side-by-side comparison of the disputed domain name and the textual components of the relevant trademark to assess whether the mark is recognizable within the disputed domain name. So I'm not sure that this is an area where you need to go down the very, very expensive survey evidence route, but I'm happy to defer to John.
Again, typical legal answer, it depends on the circumstances, probably. I think in the majority of situations, there especially with the cipher squatting or typer squatting or that kind of thing, there usually is not a response. That tends to be more the norm, if you will. Therefore, I would not necessarily go and get involved to that extent with that expense if there were other points of evidence you could demonstrate, such as we've used here, very similar websites to which the disputed domain names resolve. On the face of it, to a person looking at it, there certainly was an attempt to pass off and to make confusingly similar products. A very similar type of domain name without a valid reason for being so. And again, I go back to my favorite Armani situation. So I'd start with those before I expended the funds to do the type of survey that was involved in the question.
And John, again, the standard of proof in these matters?
The balance of probabilities is basically, it's not an absolute standard.
Right. I see that we've reached the scheduled end of our presentation. It's just past the bottom of the hour in most time zones, except for Newfoundland and Labrador. We thank everyone for participating. Really want to thank John and Georgina for their contribution. I know a lot of time and effort went into preparing this presentation. I think we delved into a considerable degree of content and at depth. So again, I want to thank you for that. I also want to thank the power behind the scenes that people observing haven't met yet. It's Ina Irigashiba at our office in Vancouver, who is the mastermind behind the scenes controlling the PowerPoint or the presentation you're seeing, and is also someone that you may end up talking to on the phone if you submit a case to our office through our website. Maybe her that responds, and if you have live questions, again, we're available to answer your questions through email or by the old-fashioned technology called the telephone. One other thing to note, this presentation will be available to people that are interested, and we are being recorded, and I'm advised that this will be posted to our website at ciidrc.org. So if there's some details that you missed, or if you want to get a refresher, this presentation will live on for posterity for some time through our website. So that, I'd like to wish everybody a great day, and also all the best for the upcoming holiday season. Stay safe, but have a good Christmas. Thank you very much.
Thank you.
I'll
Mhm.